Welcome to Legal Consolidated. My name is Professor Brett Davies. I'm a barrister of the High Court of Australia. Today we're going to learn about employment contracts. Now, if you go to our website, you'll see Home, Trust, SMSF, and any estate planning and wills, employment. So let's have a look at employment. And you can see there's many different types of documents. There's an independent contractors agreement, which is certainly not an employment relationship. There's a service trust agreement between, say, a doctor's surgery and the doctor's family. That's certainly not an employment contract. And there it is. That's the employment contract. Now, to strengthen an Australian employment contract, you should do lots of workplace policies, but we'll do those another time. So I'm going to start building a contract of employment. But before I do, I want to know things. I want my employees that leave to stop stealing my clients. We had a case recently in a financial planning practice where the financial advisor decided to do these employment contracts with all his staff, all his financial advisors, but not with the secretaries. When the head secretary left, she took the client base and started working up that client base back to her new employee, a new employer, which is not right. You need an employment contract for every single person, whether it be a cleaning person or a managing director of your business. Are restraints legal? We'll come back to that. Can the employee solicit your clients? We will look at that. And what does solicitation mean? And can we amend the contract? And we can. One of the unique factors of a legal consolidated employment contract is it can be amended from time to time by an exchange of emails. So you don't have to run off back doing an employment contract every time you decide to make changes. Can you make the employee sign a new employment contract? Now, you might have a non-legal consolidated employment contract. You might want to upgrade it to a legal consolidated employment contract, or there may be no employment contract at all. You can approach your employee next time there's an upgrade or something changes their conditions and offer them to sign a new employment contract. Can't force them, but they may not get that pay rise or that bonus or that new system if they don't. There's a lot of articles on different rules of employment contracts, but let's build one now. I press the Start Building button, and we are now in the process of building the employment contract. I can pick old documents. So if you're, say, another law firm or accounting house, a financial planning house, you've done 300 or 400 different documents, you might well find that you've got the data for one of those clients, in which case you can press the button and grab that information out. But in this instance, I'll start the contract of employment from scratch. Well, there it is. Are there hints? Well, there certainly are. Employment contracts only help employers. So here's an article on the value of an employment contract. Why do our contracts never need upgrading or updating? Because they always are read down to the modern award or to whatever laws change. And believe me, it's not only when Labor's in government, not only when Liberals in government, there's a continual change to industrial relations in Australia. Our employment contract always adjusts to whatever the latest fad of Canberra is. You as an employer have no rights. You as an employer are squashed cabbage leaf. Your only form of protection is to do an employment contract that is pro the employer. And there is no better document than a legal consolidated employment contract to protect an Australian employer. How do you amend it? Change the employment contract without employee's permission. This is a really big issue. If you've got workplace policies, what this employment contract is stating is that whatever the current workplace policies are, you have to adopt them. As an employee, you're forced under the employment contract to adopt the workplace practices, the workplace policies from time to time of your employer. Very powerful. And that's a good reason to make sure you upgrade to a legal consolidated employment contract. Now, in this instance, the employer is a company. Cook, Coco nominees, Proprietary Limited. It's going to be trustee of a family trust, which is a very common structure. So there's a trustee, and it's the Sydney Family Trust. So the word "the" is already in it, so there it is. So it's Coco nominees, and that's the employer, and it operates through a family trust. Notice I've got a green tick. That means legal consolidated barristers and solicitors are happy that you've answered the logic flow of that particular question. Now the employee is Dean Smith. It's asking for the position and one of accountant assistant. Full name is Joanne Weller. And her date of birth, occupation is an accountant. And, 78 Hobart Street in New Lambton in the beautiful state of New South Wales. And now I've got my employee. I've got a green tick. I can move on, so I press next. Now the responsibilities, it's pretty important to get down as much as you can here, because once you employ this person, their responsibilities, while you can add to it, certainly difficult to do so. So there's a training video on responsibilities. I encourage you to watch it. Can you select further responsibilities? Yes, you can. And why don't I select both boxes? Well, as much as possible. So the common to employee responsibility is completing work as directed by the boss and administration as directed. Now, most people will pick both boxes, but if they're not doing administration, you would only pick the top box. Further responsibilities, yes. Now, if they're doing a bit of marketing, why not? And expanding the employer's client base, maintaining the employer's existing systems, developing and growing employer's business. Very common to put those in. Their responsibilities. Next, duties. Well, I think I'll pick up all of those. They look a little bit repetitive to the responsibilities. They are. Duplications, very common way of protecting yourself as an employer. Additional duties, yes. Removing rubbish from rubbish bins. So I've got a green tick, I'm happy, done. Now, when does the employment start? It will be as advised by the employer. So, or you may well have decided a specific date. So let's say it's going to be, say the 18th of January 2024. That will be the start date. You can amend it by an exchange of emails. That's good. But we'll make it that date for the time being, because that's the date that the employee said she wanted to start. Probation periods. Now look, you can put in 1,000 days, but I can tell you now, as the hints will show, the probationary period shouldn't be much over the 90-day period. It would be unlikely that a junior person would have a 90-day, and this person's junior, so I'm only going to have a probation period of 30 days. Professor Davies, what's a probation period? Well, the probation period is the opportunity for you or for your employee to leave with some dignity on 2 days' notice. Sorry, Joanne, you've been with us for a week. It hasn't worked out. I'm terminating under the probation period, and I'll pay you out 2 days, because you can actually they don't have to work those 2 days. They can merely be paid out because the employment contract says so. Or Joanne sees it's not working for her and she can give you notice. That's how the probation period works. After 30 days, so I've made Joanne's probation period 30 days. That's it, you're finished. You can't use the probation period any further. If you were to make the 60 days, I don't think you're going to get away with it. I think 30 days is best for the junior, up to 90 days for a very senior person. The hints will explain which and why. Is the employer required to undertake a medical examination? I'm going to press no. The salary, it's going to be full-time. The salary will be $96,400. The salary will be paid monthly in arrears. That's how it's mostly done these days, but in this case, we've got to pay fortnightly in arrears. She is an assistant accountant after all, so. Next. At any time the employer or employee may wish to terminate this contract, well, normally it's about 30 days. So, look, you've been with us for a couple of years now. We're no longer able to employ you because we don't have enough work, and we'll pay you out the 30 days, or we can work out the 30 days at the decision of the employer. Well, what's a confidentiality clause? Well, you've got to keep things secret of what we're doing. We're an engineering business. We have secrets. We're Coca-Cola. We've got secret recipes. We've got secret ways of doing things. We've got a very unique way of dealing in our ice cream company and how we manufacture ice cream. These are all things that are confidential you cannot use. The confidential period, non-competition clause, so you can't compete against us. Now that's interesting because if you are a dentist and you're working in my dentist practice, I can stop you doing certain things, but I can't stop you from being a dentist. I can't stop you fulfilling your trade or your profession. And this employment contract does not seek to do that. It goes as far as it can, but it does not seek to do that. Additional terms such as motor vehicles and things can all be done by an exchange of emails from time to time. So the reference is the document name. I believe it's contract of employment. If you are, let's say you're financial planning practice and you're building this, you might want to put your initials in. So my initials are BKD. What's your initials? UM, and then the matter reference number. But if you're just a mum and dad, well, just leave it as employment contract for Joanne. It's only for you, help you in years to come to try and find the document. If you've done 400 or 500 documents, you ought to be able to find the employment contract for Joanne. I would like to have my business logo on the document. So maybe you're an accounting house, you'd like to have your logo on there. It will sit next to Legal Consolidated's logo. I can select a box and remove Legal Consolidated's logo, but only another law firm would do that. I'd select a box of print and bind, and I'm going to also get one of the lawyers to ring up the client and go through the employment contract. Not the employee, but the employer. But in this instance, I don't want it. Now I'm at the summary, and look, I've got lock and build. I'm going to go to lock and build, but I'm not going to press it. Instead, I'm going to go to employer, and I'm going to take Coco out. Now, lock and build's gone missing because there's something here. Legal Consolidated is responsible for this document. You may be building the document, but you're a mere scribe. We are responsible. Our law firm, our Australian law firm is responsible for this document. So the security is very, very tight, and our logic flow is very, very tight. And you're going to be producing here a locked PDF document. It's a finished document with that covering letter. It's locked. If you need to amend it, email us. We'll send you a voucher to update it if you made a spelling error or you just don't need the document anymore because Joanne may not have started with you. Your full money back guarantee. So then company name, Coco, that looks right. Company ACN, 9 numbers, good. There is a trust, Sydney Family Trust. Looks good. Lots of opportunities there, protecting the client. Right, I'm going to press lock and build. And I'm going to put my credit card details in. And there it is. my document has been created. My employment contract is there. I'm excited, so I'm going to have a look at it now. It's gone in your documents, and there it will stay forever, and so is the data. It always stays there forever, so in 20 years' time, use it again. But I'm too excited to look at the data. I want to look at my finished product. I want to look at my contract of employment. So I've downloaded it, and there it is. Wow. So you see it's on the law firm's letterhead. The first thing it says is, thank you for instructing us, legal consolidated barristers, solicitors, to prepare the attached contract of employment. That's how to print it. Wow, this is good gardening leave. Good information. And there is the employment contract for you to give to Joanne. You can print it out, get her to sign it. Probationary period is 30 days. I know you wanted 90 days, but she's too junior. Given that salary, maybe you should have made it 60 days. It's your call. Termination without notice, termination with notice, pay in lieu of notice, which means that you can just pay her out those 30 days if you wanted to. Confidentiality. Now, this is one of the real skill sets of legal consolidated barristers, solicitors. You'll love this. The trade secrets, the suppliers, even the suppliers. We've got a client and their provision of supplies from overseas in China is quite unique, and their system of bringing the assets or bringing the materials in is quite unique. It's confidential. That building company's got a distinct advantage over others, and they want to keep it confidential so that this will lock in the employee not to share that information. Now, confidentiality following termination, that's interesting. So the employee's gone, but they're still liable. That's pretty good. They're still liable. Now, have a look at this clause 16, this confidentiality, because it's got what they call the blue line principle, because you want 100 kilometres, but if the court says that's too wide, they put a blue line through it and you get down to 10 kilometres. So this is designed so that if the restriction is too wide, you can still enforce a bit of it. The next thing is inventions, records and documents. I mean, your mobile telephone. What have you done with my mobile phone? No, you keep it, that's all right. So your mobile phone's full of information. The computer's full of information. You want to make sure at the end of the day that they can't use it. Maybe they're using their laptop. They've got your client's database on there. Or they've got those secret book. McDonald's have the Bible, which says exactly how their shops are to operate. You don't want that going out in the public community. So these inventions and records and documents all belong to the employer. Confidentiality. There's a salary component. Set off, superannuation. Everything's contained in here. Location of work can change. The employee is agreeing that you can change the place of location of work. Long service leave. Now, the reason this document is always up to date is because the laws override the terms of this agreement. It says so in the agreement that at all times, the modern awards or whatever's compulsory, the employment contract be read down, and that's what gives you the protection. So that's it in a nutshell. That's your employment contract. If you need a hand building the document, telephone the law firm anytime, and we'll give you a hand building it. Enjoy.